Good afternoon to all of you. A hearty welcome again to all to this session on the topic industrial and employment relations. Yesterday's session, I have discussed the concept and approaches to industrial relations. In today's discussion, I will be covering the evolution of industrial relations in the Indian context. If you take into account the development of industrial relations in the Indian context, obviously it does not have so much of a long history because industrial revolution is instrumental for development of industrial relations. So you can just trace it back to sometime in the mid 19th century, mostly 1850s, when the modern factory system started emerging in India. And initially, obviously, as you can find it out, the textile industry which started in India, mostly in the western part of the country, in the Delhi and Bombay presidency, in Bombay, Surat, Ahmedabad, and so on. And gradually, obviously, when the industrialization spread and new type of industry started emerging, resulting into increase in employment of industrial workers, the consequence effect that was visible on the workers resulted into either dissatisfaction among the workers, giving rise to industrial disputes or conflict, which manifested in the form of strikes, work stoppages, and so on. So if you take into account the development that has taken place in the Indian context, though the progress can be considered to be incremental, very slow process, which began particularly during the pre-independence period when the country was under the rule of the Britishers. And subsequently, when the country got its independence in 1947, with our constitution and our legislative framework, the industrial relations scenario, either at the micro level or at the micro level, is also being regulated by the provisions of the law, though there is also element of voluntarism involved in guiding the relation between employer and employees or labor and management at different levels. Though there can be traces where, if you take into account Chanakya's Arthashastra or Muni Sahinsa and so on, there may be some relevance of the employer and employee relationship because, as I told you, employer-employee relationship is dependent on employment. But the way that we consider it in the present-day context, the relationship was obviously not to that an extent present or guided by those different kind of principles or parameters in the past. The discussion with regard to the evolution of industrial relation in Indian context can be made in two different ways. One, you can discuss it in a time frame. And when you take into account the time frame, you can divide it into two components. One is the development that particularly has taken place prior to independence. And the second phase is the post-independence period. Again, if you take into account the pre-independence period, You can again divide it into two components, two phases. One is from the mid-19th century up to the end of the First World War, or to be more specific, in 1918. And the second phase of the pre-independence period can be during the period from 1919 to 1947. This second phase obviously includes not only the people as they call the interwar period, but also the Second World War period. Post-economic, post-independence era similarly can be divided into two different components, two different phases. One is 1947 to maybe 1989 or 90. And the second phase is particularly 1991 onwards. Because 91, I take into account a particular year when there is a substantial change in the economic policy of the then Indian government, which is still continuing. So this can be spread over in a time frame, two different phases prior to independence, mostly starting with the 1850s to 1918, 1919 to 1947 in the second phase during the pre-independence period. Post-independence period, 1947, just after independence up to 1990, and 91 onwards still late. This is specifically with the reason that various factors obviously have played or have been influential in shaping up the growth or the transformation of industrializations. The other way that it can be discussed also is with regard to taking into account the different features of industrializations. Now, because industrialization depends upon or is being influenced upon by various factors, or it can consist of various components as the characteristics of industrializations that you can take. Normally, if you take into account, industrialization is not independent of its own. It depends upon the various factors. Either it is being influenced by certain factors, or there are certain inherent components within the industrialization system that are to be taken into account. So the other way one can discuss is with regard to the features of industrializations. What kind of changes that have taken place with regard to these features? When you take into account the features, specifically you can take into account one important component of that is with regard to the trade unions. That means the formation and the growth of the trade unions as a component of the industrialization system. Second, industrializations, as I've told you, there is not only with regard to certain kind of voluntarism, but to some extent you can find that it is being regulated by different kind of legislations. Because industrializations which to a larger extent, which believes or which aim particularly to have some kind of a positive or healthy relation between employer and employees, there must be some kind of a, first of all, preventive measures, which obviously will lead to elimination of any kind of conflict. And obviously law plays a very major role here for making a platform of ensuring the minimum facilities so that this can be claimed as a matter of right on the part of the workers, or making them as legal obligation on the part of the employer to be provided, thereby to a larger extent eliminating various areas of conflict. So law, the second aspect in terms of industrialization is with regard to what kind of growth that has taken place with regard to labor legislation in India and how that it has contributed or shaped up the industrialization scenario in the country. Third is if you take into account industrializations in the theoretical context, if you take, there are two different components normally people take into account or literature suggests. One aspect is cooperation, the other is conflict. Now, both are obviously contributed to each other. In the sense, if you avoid conflict, it will result into developing cooperation. If you develop cooperation, it results into eliminating or reducing conflict. So, in spite of this emphasis, what is normally believed or taken to be inevitable, that there would be obviously, even if that there are legislations, legal provisions, you cannot rule out any that there will not be any kind of conflict between the labor and management, or there would be obviously disputes can be considered to be inevitable. Now, if disputes are inevitable, efforts always should again be made to resolve them. You cannot just leave them as such to continue. So, what are the mechanisms with regard to the resolution of the disputes that may arise from time to time between employer and the employees? So, in this regard, in Indian context, what are the different machineries or authorities that play a role for eliminating either the disputes or resolving the disputes? At the same time, if you take into account, cooperation is also an important element. And cooperation, what I talk about here, or when we emphasize here, is with regard to the workers' participation in management. What are the different institutions that have been, suppose, initiated or institutionalized in the Indian context with regard to furthering the cooperation between the employer and the employees? And finally, obviously, one can take into account with regard to what is the role of the government, either in terms of resolving the disputes, developing cooperation with regard to making legislation, or their, most importantly, with regard to their administration. Because when you take into account the role of the government, another feature that also comes in the arena of industrializations is tripartitism. Normally we believe, or normally we take into account there are two parties in a dispute, that the labor and the management, or the employer and the employees. But sometimes you can take into account that government can also be associated, and there can be a concerted effort, a combined effort between the management, the employer, management or the employer, the worker and their organization, and also the government sitting together to discuss and decide issues relating to labor. So in one way, moving away from the time frame, if you take into account some of the features of industrializations, one can take into account the trade unionism, one can take into account the legal framework with regard to labor, one can take into account the machineries available with regard to resolving industrial disputes, machineries or the institutions that have been provided, created, whether under statute or voluntarily with regard to cooperation, and finally the role of the government as a mediator or as a lawmaker or as an administrator. My discussion obviously will relate both the aspects with regard to the time frame and also with regard to the features. So, but I will I will take up my discussion particularly taking into account the features instead of taking the time frame, because that will be, when I will discussing the different features, obviously time frame will automatically be coming in. So first, let us take into account the first feature with regard to trade unionism, which is obviously one of the important component of any industrialization system, the organization of the workers. Now, if you look into the 1850s, when modern industries, the modern factory system particularly emerged in India. But prior to that, obviously, there were some other activities where people were engaged. And one activity that can be taken up was at that particular point of time was a plantation in the Indian state of the province of Assam. And most of the labor employed in the tea plantations in Assam at that particular time mostly were migrated labor, mostly moving from either West Bengal or Bihar or Orissa and so on, finding employment. And when people in that particular time, 1850s, if you take into account, when people started to return back to their homes, they were not allowed to come back. Because 1859, the then British government enacted a particular legislation known as the Tea Plantation Immigrant Act, which prohibited the movement of the plantation workers from Assam to their homesteads. Because at that particular point of time, again, the owners of the tea plantations are most of the Britishers. So when the workers, mostly from these states, if they come back, and mostly guided by the so-called Swaraj movement and the Gandhi's movement of providing employment in their own villages, there will be shortage of workers and plantations, and the production of tea leaves or plantation will be affected. So they enacted this particular law of prohibiting the free movement of the labor from the province of Assam to their home states. At that particular point of time also, there are some other legislation that were also enacted. Another act was known as the Fatal Accident Act of 1855. And 1859, there was another legislation that was enacted, the Workmen's Breach of Contract Act. To a larger extent, though these relate to labor, but these legislations are mostly pro-employer. Tea Immigrant Act, as I have told you, is prohibited the movement of the people from the plantations. Workmen's Breach of Contract Act said that if the workers resort to work stoppages, that will be considered to be a criminal offense. It is a criminal breach of contract between the employer and employee, and they will be punishable. Similarly, if you take into account the Fatal Accident Act, which particularly provided provisions for compensation for people who where death results because of an accident, and compensation will be paid to, in such cases, to the dependents. But in such cases, it is the dependents of the deceased employee has to prove that the accident has been caused because of the fault of the employer. Then only that the compensation would be payable to them. So the relation between employer and employee, whether it is with regard to continuation of employment, which was no more a free choice on the part of the employees or the workers, neither the workers, in spite of any suffering, can raise their voice in order and to go for work stoppages for furtherance of their demands, either which are considered to be justified on their part, or even in case of the death of the employee, hardly that they will be entitled for any compensation, because sometimes it is very difficult on the part of the deceased employee's dependents to prove that accident has been caused because of the negligence of the employer. Whatever it may be, some initiation was made in 1850s with regard to law coming in the form of regulating the relation between labor and the management. Though maybe, as I've already told you, these are considered to be more in favor of the employers. Subsequently, the factory, as the number of factories gradually increased, and employment in the factories started increasing in the form of a textile mill in the west or jute mill in the east side, in the west, in Bengal. the suffering of the people in the different manufacturing sector came to the forefront. 1870s, different commissions of inquiry which was appointed in order to find out the condition of labor, particularly in the textile industry in Bombay Presidency, revealed horrible situation with regard to employment of women, employment of children of tender age, inordinate longer hours of work, absence of any kind of safety measure, or absence of any kind of a physically, suppose, hygienic working condition and living condition. Now, this showed particularly the suffering of the textile workers employed in these factories, and as a result of which, in 1881, the first Factories Act was enacted. Though initially, when the act was enacted, it was applicable only to the factories which were employing 100 workers, and hardly it regulated the working conditions and so on, but it at least prohibited the employment of children of specific age and made some provision with regard to safety. At that particular point of time, there was absence of any such organization that you can call as the workers' organizations, or the present day that what we find in terms of trade unions. But some philanthropists or some persons being moved by the suffering of the workers, by humanitarian consideration, started forming association for the workers. Because trade union normally can be considered to be association of the workers. But in the late 19th century, to be more specific, in 1890, one particular such association that was formed by N.M. Lokhande, and that is known as the Bombay Mill Hands Association. N.M. Lokhande is considered to be the father of the trade union movement or the labor movement in the country. So this Bombay Mill Hand Association is an association though consists of the workers employed, but this is mostly considered to be an association for the textile mill workers, raising the voice of the textile workers, putting forward with regard to the suffering of the workers in the public or before different kind of government agencies and so on. Some more unions that came to being during that particular period also. In 1897, the Amalgamated Society of Railway Servants in India was formed. 1904 or 1904, you find another particular association in Mumbai, or in Bombay, the Kamgar Hitvartak Sabha. These are some of the initial steps that were made with regard to organizing the workers, but these cannot be called as the organization of workers because these are hardly any feature having the characteristics of the present trade union. These are mostly friendly associations, voluntary associations working for the well-being and welfare of the employees. But in the meantime, obviously, by formation of these associations, and there are certain instances that obviously took place during the later part of the 19th century, brought a twist with regard to the industrial relation scenario in the country. Now, by 1870s, as a number of factories in different parts of the country, particularly textile manufacturing sector, has expanded, one witnesses certain kind of work stoppages, mostly in the 1870s. One example where you find some kind of work stoppage took place was the Empress Mill at Nagpur. And similarly, in 1870s, strikes were reported have taken place in Bombay Presidency. in Surat, and in also in Ahmedabad, the textile mills. So obviously, the workers, though at that particular point of time were not so organized, but still the suffering of the workers or the exploitative practices of the employers probably have led to protest, to raise protest on the part of the worker, resulting into work stoppages. Later, however, in the turn of the 20th century, things started changing, and trade unions in the present context, what we find, mostly started emerging in the second decade of the 20th century, after 1910 onwards. In the meantime, obviously, if you take into account, as you know, the First World War, which spread over 1915 to 1918, and during the war period, obviously, as there was a lot of demand for production and supply of goods, war needs, and so on, there was continuous employment and so on. But after the war was over and the demand for the different kind of products fell down, its effect can be visible in different organizations, and there was resulting into wide-scale unemployment or wage cuts and so on. At the same time, also, the economy suffered from inflation or the price rises. So either because of unemployment or wage cuts or layoffs and increasing prices, the living condition of the working class obviously started deteriorating. And as there was a greater degree of agitation on the part of the workers in the form of raising demands before the employer for increasing the wages to mitigate the difficulties that they were suffering from. One such incident that particularly took place in 1921, that is in a particular mill, textile mill in Madras, that is known as the Buckingham Karnataka Mills. Popularly, that was known as the Penny Mills. And one Mr. B.P. Wadia, who was the secretary of the union, formed the Madras Labor Union, one of the oldest union in the trade union history in the country. And they raised a demand before the employer for raising the wages. And the employer did not concede to the demands. The workers went on a strike. The strike almost continued for 6 months. But because of the different kind of pressure tactics or the pressure that the employer imposed, ultimately the worker had to come back or has to withdraw the strike. And though the employees are supposed to come back to work, but majority of the workers are never re-employed by the employer. At the same time, because the employer has suffered from loss of production, there was a legal case filed against Mr. B.P. Wadia and Madras Labor Union. And at that particular point of time, still as the workmen's breach of contract work was in vogue, the leaders of Madras Labor Union, and more specifically B.P. Wadia, was convicted. And a heavy fine was imposed upon him, or in the absence of payment of the fine, he is supposed to be imprisoned and sent to Kalapani. This obviously created a hue and cry, not only in India, but also in UK. Because by that time, formation of trade union has been legalized by the British Trade Union Act. But that particular right of formation of trade union as legal entities was not, I suppose, operational in India, because formation of trade union still was considered to be a conspiracy against the British government. And as such, people involved in formation of the trade union were considered to be anti-British and can be punishable under the then existing law. However, with a lot of public pressure and public opinion, not only in India but also in the UK, ultimately the then British government in India enacted the law relating to trade unions, known as the Trade Unions Act of 1926, which legalized the formation of the trade unions. Before that, however, another dissident or development that took place, though formation of unions was relatively obviously late in India, mostly if you can take into account the beginning of the 20th century. But trade unions in different Western nations or where industrialization has started early and industrial workers has already made a beginning, and trade union formation to some extent has been legalized. Trade unions have been formed there, and there were efforts even for formation of trade union at the international level. So there were instances with regard to the formation of the first international, second international, with regard to giving a international platform for the different trade unions functioning in different countries. 1918, when the First World War came to an end, as you know, that League of Nations was formed in order to regulate the relation between the different countries all over the world for the purpose of maintaining, restoring and maintaining peace. And as a part of the League of Nations, as labor was considered to be also to be taken up at the international level, the International Labour Organization was formed in 1919 as one of the wings of the, or one of the institutions of the League of Nations. Subsequently, the development that took place, which ultimately resulted into 1939, the Second World War. By that time, obviously, the League of Nations has almost become defunct, but the International Labour Organization sustained its existence. And the International Labour Organization, 1919 onwards, have also made efforts, particularly to develop some kind of a universal labor standards and to be implemented by the member countries for the purpose of providing some kind of a fair treatment to the labor class. Now, as the International Labour Organization, the tripartite body, having representation from the employer, from the employees, or the labor, and also the government. And in 1919, India was also a founding member, though it was under the colonial rule of the British, but for the purpose of its representation in the International Labour Organization, India was a founding member. And since 1921, India has become a permanent member in the governing body of the governing council of the International Labour Organization. So, an International Labour Organization had a provision where that every year there would be an International Labour Conference, which is to be attended by delegates from the member state, comprising of representatives from the employer, from the employees and the government, in the ratio of 1:1:2. That means one representative in the ratio of one representative from the employer, one representative from the employee, and two representative from the government. That is ratio 1:1:2. In order to maintain a balance, not only between employer representative and employee representatives, but at the same time with regard to employers and employee representation together with that of the government representatives. So when the question came with regard to representation of the labor or the workers or the employees in India at the international level, there was obviously no national level organization in India to represent the Indian workers at the International Labour Organization. Though by that time, some unions have come up at the unit level or plant level or at the industry level. Example, suppose if you take into account the Madras Labour Union, if you take into account by say 1920s, Ahmedabad Textile Labour Association in Ahmedabad, particularly take into account the textile workers employed in Ahmedabad. Uh, in different parts also, you find the existence of kind of trade unions. But all these unions either are unit or plant-based, or maybe if you take into account Ahmedabad Textile Labor Association, it is a region, a particular region and a particular, I suppose, the textile industry only. But national representation of the employees should be done through a national level organization. So in 1920, the then Congress, which was on the forefront of the freedom struggle of the country of India, formed the labor of its own labor wing known as the All India Trade Union Congress. That is the first national level trade union federation to be formed in India by the then Congress party, or the Congress, not the Congress party, but by the Congress which was fighting at that particular point of time. Now, so what you find here, the formal trade unions started taking place in the 1920s and legalized by the Trade Union Act 1926. And in 1919 or 1921, you find the formation of the 1920, you form the formation of the All India Trade Union Congress. This is the beginning with regard to trade union activity in the country, and also with regard to some of the legislation that came into being, regulating the relation between employer and employees. More specifically, if you take into account the Trade Unions Act 1926. However, if you take into account another particular aspect with regard to law, and that too with regard to some kind of an exigency in the form of the social security, and that too with regard to some kind of an extension of benefit to the employee. As I have told you earlier, that there was a particular act known as the Fatal Accident Act of 1855 that was there, which was subsequently, however, replaced by another particular legislation known as the Employees Compensation Act, or the Workmen's Compensation Act 1923. Now, the difference between here is that the Fatal Accident Act was only limited in case for the purpose of compensation in case of death. The Workmen's Compensation Act made a provision not only for the in case of death, but also with regard to temporary or permanent disability, and also with regard to some kind of occupational diseases. And the table also turned here in favor of the workers, in the sense, if there is any kind of an accident and compensation has to be paid, unlike in the Fatal Accident Act where the dependents of the employee have to prove that the employer is guilty, here the employer has to prove that he is innocent. Then only that the employer will not be legally, the employer will not be obligatory on the part of payment of compensation. So now the advantage is on the part of the workman. Subsequently, later you will find that the title of the Workmen's Compensation Act was changed to Employees Compensation Act, broadening particularly the definition of the employee, covering different type of employees under the provisions of the Act. Coming back to the trade union development as one of the component, 1920, as you know, that the AITC was formed, but at the national level, if you look into the trade union movement in the country, has some kind of a very fragmented, or maybe there are a lot of divisions in the trade union movement, ultimately resulting into multiplicity of trade unions, not only at the national level, but its reflection can also be found at the plant level or at the regional level. Now, after formation of the AITC in 1920, the first split occurred is in 1929 in one of its annual conferences, which was held in Nagpur, where a particular faction of the members of the AIUTC and who were considered themselves as moderates under the leadership of N.M. Joshi, settled away from the AIUTC, and they formed another their own union known as the All India Trade Union Federation. This is the beginning of the fragmentation of trade union movement in the country. Subsequently, 1929 to almost 1941, there are a lot of divisions, lot of factions, which have resulted into formation of different kind of unions at the national level under different kind of names. For example, if you take into account, I cite some other unions that have been formed during this particular period. Another group settled away in 1931. They formed Red Trade Union Congress. 1933, there was another division which resulted into the All India Trade Union Federation and All India Railwaymen's Federation. So you will find there were some factions going out of the AITUC, forming their own association. Sometimes they were coming back again. There was some kind of understanding and coming back. So this fragmentation and assimilation was continuously going on. And that obviously did not show a solidarity with regard to the working class, though they were fighting along with the national leaders for the purpose of the freedom struggle. The workers being associated with that, national leaders were also associated with the trade movement of the country. People like, suppose, B.V. Giri, Gulzar Dal Nanda, if you take into account Khandubhai Desai, who ultimately subsequently became the labor minister after independence, they were greatly associated with the trade movement and equal with the nationalist movement. However, with all this kind of division and all that were taking place, finally, again in 1941, in its own annual conference in Nagpur again, which saw the first split. In 1941, all the different factions, obviously, they ultimately came together and merged with AITUC. But again, that remained short-lived. I will tell you again what subsequent development that have taken place. In the meantime, if you look into the development in terms of legislation, during the pre-independence period, we find that relation between employer and employed to a larger extent can be regulated. And as such, in 1929, the government, British government, enacted a particular act known as the Trade Disputes Act, 1929, in order to regulate the relations. Initially, though, it was considered to be only for the period of 5 years, but in 1934, the act was being made permanent, and which made a provision with regard to this dispute resolution between the employer and employees in different industries or different organizations, which were called at a particular time as the trade disputes between the employer and employees and so on. Now, in the meantime, there is continuously the International Labour Organization, through its conventions and recommendations, was guiding the member state particularly to take up steps for the purpose of providing different kind of provisions for the labor. So by the turn of the by the end of the Second World War, 1945, certain kind of development that have taken place with regard to the industrial scenario in the country. 1939, as you know, the Second World War began, and keeping into view the war demands, Government of India at that particular point of time declared the Defense of India rule, or implemented Defense of India rule, which prohibited the strike and lockouts or work stoppages of any form in the different industries. And if there is any kind of a dispute, it made a provision for the purpose of resolving them through arbitration. But this continued till almost the end of the Second World War. And in 1947, however, the Industrial Disputes Act was enacted, which made specific provision with regard to handling the industrial disputes, providing machineries for the purpose of resolving the disputes between the employer and the workmen, or workmen and workmen, and employers and employers. It also made provision for the purpose of providing forums for the participation of workers in the management. Simultaneously, obviously, trade movement was going on, and though 1941 there was some efforts with regard to unification in the All India Trade Union Congress, but it was also short-lived because there were two different factions that were operating in AITUC. One, some were considered to be relatively more radical, more considered to be more, I suppose, direct action oriented, and some people who were considered to be themselves more moderates. And ultimately, when the radicals obviously dominated the activities of the AITUC, the then leadership of the Congress decided to form their own labor wing. And in 1947, a second national level federation came into being that is known as the Indian National Trade Union Congress, or in short, INTUC. The fragmentation, however, did not end here, because if you review the trade union history as part of the industrial relations history, you can find at different periods of time different type of under different names, with different ideology, with different political background. A number of national level trade unions have been formed. After the formation of the INTUC in 1947, another national level union was formed that is known as the Hind Mazdoor Sabha in 1948, United Trade Union Congress in 1949, the BMS as a wing of the Dijan Jansan Party, which was formed in 1951. Its labor wing was started in 1955, Bharatiya Mazdoor Sangh. After the split of the Communist Party of India, because AITUC, when the INTUC was formed and it was belonged to the Congress Party, the first national level union which was formed in the form of AITUC came to the forefront with the fold of the Communist Party of India. Now, with the split of the Communist Party of India into two, CPI-M merging as a separate Communist Party in 1964, though there was no immediate split in the AITUC, they continued for some time. But in 1970, the leadership of CPI-M thought that they can have their own union at the national level. So some of the members who were functioning in AITUC and more inclined towards CPI-M, this separated themselves from that, and the CITU was formed, CITU, Center of Indian Trade Unions, in 1970. Subsequently, there are a number of other organizations, though short-lived National Labour Organization. There was a split again in UTUC, came being. So 19 to 20, if you take into account 1972, there was almost 8 to 10 different national level unions that were functioning in the country, and with each particular union having its affiliation to a particular political party. So if there is any kind of a split in a political party, then obviously its effect can be visible in the trade union front. And the same still is continuing even after the independence period. Rather, now it has been further, suppose, gone down or has weakened because of the emergence of the regional parties in different states, and each regional party is trying to have its own labor wing within that particular state. So you can find not only at the national level, but also at the regional level also, there is still fragmentation of the trade union movement in the country. This is the status of affairs with regard to the trade union movement. Coming to the labor legislation, let us continue with that what has happened in the pre-independence period. Mostly, if you take into account, some of the legislation that were enacted was your Employees Compensation Act 1920, or the Workmen Compensation Act 1923, subsequently changed to Employee Compensation Act. Trade Unions Act 1926. Another important act that was enacted that particular period of time with a great relevance for regulating the employment relationship is the payment of wages in 1936, because prior to that, there was no such regulation dealing with timely payment of wages or payment of wages in the legally acceptable medium, or prohibiting the employer particularly for imposing unilaterally any penalty or fine upon the employees and ultimately deducting them from the wages. So in order to ensure timely payment of wages and the legal way of payment of wages, and prohibiting any kind of arbitrary deduction from the employer by the employer on from the wages of the employees, the Payment of Wages Act came a relief to the workers. This is mostly because of the recommendation of another particular commission that was appointed at a particular point of time, 1929, the Royal Commission on Labour, which submitted a report in 1931. And this 31 Royal Commission on Labour report, to a larger extent, can also be considered to be contributed for the development of different kind of provisions for the labour. 1935, another act that came into being was the Government of India Act, and under this provision, elections were held, and in 1937, different popular Congress ministries were formed in the different provinces, region provinces. And one of the manifesto that Congress at the particular time contesting election in these provinces gave was to give a fair deal or fair treatment to the working class. And when the formation of the government took place in some of the provinces, they started working, obviously, for the betterment of the workers, either by appointing commissions or bringing out changes. But the government was short-lived, because by 1939, when the Second World War broke, there was a difference of opinion in the Congress with regard to whether supporting World War. By that time, India had joined, Indian armed forces have joined with the Britishers. And as such, many of the, as per the decision of the Congress, the ministries resigned. After 1947, if you take into account the post-independence period development, a lot of development that have taken place in order to ensure the well-being of the workers, and thereby to a larger extent regulating the worker management relationship or employer-employee relationship. Primary was the, obviously, with regard to regulating them is the Industrial Disputes Act of 1947. So this has made a provision, it has not only provision with regard to the preventive measures, but it also has measures with regard to the reactive or remedial measures. It created specific institutions. 3 different institutions were created as part and parcel of the industrial relations machinery. One is the conciliation through the process of mediation. Second, voluntary arbitration by the appointment of mutually agreed upon arbitrators by the parties involved in a dispute. And third, the adjudication process, which is considered to be the quasi-judiciary, by formation of different kind of institutions in the name of labor code or the industrial tribunal or national tribunal by the appropriate governments. So first, obviously, it made a provision, though another particular institution which play an important role also with regard to either preventing or resolving industrial disputes, collective bargaining, which is based on the principle of mutual acceptance of the demands and mutual discussion, negotiation between them. But in Indian context, this has not been got any kind of a legal sanction, because this is not a provision under any of the law. So voluntarily, obviously, collective bargaining is being practiced not only at the plant level, but regional level, even at the national level or at the industry level. But legally, if you take into account, citing the provisions of the Industrial Disputes Act, you can take into account conciliation, voluntary arbitration, and adjudication as the different legal machineries provided under the ambit of the Industrial Disputes Act. Now, there was an incident which we cite again here with regard to industrial relations. When Jagjeevan Ram was the first labor minister in India after independence, who was subsequently replaced by B.V. Giri as the labor minister in 1950s. V.V. Giri was particularly a person who was propagating to popularize collective bargaining, but that was not acceptable to the then Congress. And because of some kind of a moral misunderstanding between what Giri wanted as a labor minister, which was ultimately not acceptable to the Congress leadership at that particular point of time, V.V. Giri resigned as the labor minister and who was subsequently replaced by Kandubhai Desai as the labor minister in 1958, 55, because 1958 Gulzari Nanda became the labor minister. So during this particular 55, 50s, late 1950s, another development that took place in the industrialization scenario in the country, and particularly under the leadership of Khandobhai Desai as the labor minister, where he said from court to the code. That means labor code, if you take into account, or the industrial tribunal, if you take into account, these are quasi-judicial bodies, just like any other court. A lot of difference between a formal court and with regard to these type of organizations. But he said, emphasized with regard to voluntarism. And about that time also, another particular feature that have emerged in India in 1940s, rather I will say 1930s, with regard to the labor minister conference after the formation of the popular ministries in 1937. And this culminated in the form of beginning of tripartitism in India in the industrialization scenario, where the Indian Labour Conference was constituted. And in 1942, its first meeting was held. Subsequently, there was continuously to some every year the ILC met and made subsequent very significant contribution. And this is purely a voluntary body comprising of the three parties, namely the employer, employee, and the government, with the same proportional representation, the same structure like the International Labour Organization. So in 1958, the Indian Labour Conference made a particular document that is known as the Code of Discipline, where it incorporated various provisions relating to grievance handling, how that grievance of the employees can be redressed, how that trade unions can be recognized, what should be the conduct with regard to the management or union, what should be the approach of the management for the union, and so on. And these are all considered to be done through voluntary method. So the popular slogan that came in the 1950s was, let us move away from the court to that of the code. That means let us have some kind of more of voluntarism than with regard to depending upon the legal mechanism. At the same time, there were also efforts that have been made with regard to popularizing workers' participation in management. If you take into account the Works Committee provision under the Industrial Disputes Act, and subsequently in 1950s, through voluntary method, the Joint Management Council. This was again a recommendation based upon made by the Indian Labour Conference, basing upon a tripartite committee that was constituted, which went through different kind of Western nations, the model of workers' participation management prevalent in those countries, and suggested a particular model which was discussed and with some improvement or changes accepted by the Indian Labour Conference and considered to be and resolved to be implemented in relatively larger organization than the formation of the Works Committee, because it recommended with regard to formation of the Joint Management Council would be organization which have 500 or more workers, and that to be voluntarily, where the Works Committee was considered to be a statutory body. Subsequently, obviously, in 1970s, some efforts had been made during the period of emergency. 1975, workers' participation in industry as a part of the 20-point economic program of the then Prime Minister, Mrs. Indira Gandhi. A two-tier workers' participation model at the plant level and at the shop level, giving more opportunity to the grassroots employees to take part in the decision making of the organization. And there were also efforts that have been made in the meantime by the government in order to change the different existing legislations. In 1977, when the first non-Congress government came under the leadership Morarji Desai, the Prime Minister, and Mr. Ravindra Verma, who was the Labour Minister by then, he tried to introduce a industrialization bill 1978, comprising of three different legislation together: the Trade Unions Act, Industrial Disputes Act, and Employee Standing Orders Act. But before anything could be done, the government disintegrated, and nothing happened to that particular bill. Recently, however, in 1919 onwards, the government has taken initiative where a number of legislation have been brought together under 4 different codes. And presently, you can find all these codes have been enacted and passed by the parliament and approved by the president, but implementation is awaited because of rules by the different states have not been formulated. So presently you find the 4 codes known as the Industrial License Code, comprising of the Industrial Disputes Act, Trade Unions Act, and the Employee Standing Orders Act. The Wage Code 2019, that is comprising of the Minimum Wages Act, Payment of Wages Act, Equal Remuneration Act, and the Payment of Bonus Act. And the Social Security Code, comprising all the different social security legislations like your Employees Compensation Act, Employee State Insurance Act, Payment of Gratuity Act, Provident Fund Act, Maternity Benefit Act, and finally the Occupation Health and Safety Code 2020, comprising of the Factories Act, Contract Labor Act, Interstate Migrant Workers Act, and so on. So this is the genesis that you find with regard to the development that has taken place, taking into account the different features in terms of trade unionism, taking into account the different legislation that have came to be with regard to different machineries that have been put into vogue, with regard to the cooperation machinery that was being introduced, and also with regard to the role of the government over the period of time. If you take into account pre-independence period 1850s to 1918 to 1947, post-independence period 1947 to 1990, and 1990 onwards till date with regard to the present status is the emergence of the different codes that have come to me. Thank you very much for today's session.